In the cases where the total personal property assets that need to be transferred in a decedent's estate are worth less than $100,000, California has a simplified procedure for beneficiaries to take ownership of them. This procedure is available whether or not a decedent had a legally valid will or trust. Plus, in calculating the $100,000 limit, assets that would otherwise avoid probate are also excluded. So in other words, assets held in a trust, a joint tenancy account, life insurance paid directly to a beneficiary, and the like, are not counted when totaling the aggregate fair market value of the decedent's assets that need to be below $100,000 in order to fit within this exception. If an estate's assets do qualify for this summary procedure, though, an affidavit must be prepared and sworn to by the beneficiary of those assets. One thing to recognize is if you want to use this procedure, you should know that there is no requirement to notify the decedent's creditors like there is in a probate proceeding. But to the extent that you receive property, you may be liable for the debts of the decedent that arise in the future. At any rate, after 40 days from the date of the decedent's death has elapsed, the beneficiary fills out the affidavit. That form is then used to actually change the name on the decedent's assets. So, for example, if the decedent had an account at a bank, the affiant beneficiary simply takes the affidavit to the bank and changes title on the account with it. Finally, it's important to point out that in addition to the summary procedure outlined here for small estates, a couple other summary procedures exist for transferring property. For instance, you can transfer real property that is worth less than $20,000, as well as transfer automobiles and mobile homes with similar procedures. To find out more, please schedule a free appointment here at the Trust Store.